page 2. Page 3. Page 4. Page 5. Page 6. Seven. Page 8. Nine. 10. 11. 12. 12. Finally, page 13. Okay. If there are no corrections, can I ask, I don't see any hand up online.
Chairman.
Yes, I was expecting, yes, member guy, go ahead.
Yes, Chairman, I, being the one who asked for a postponement at the last meeting for until today, I have read the minutes and I want to commend the recording clerk for the correctness of it, and hence I want to propose that we accept the minutes.
Excellent. Thank you very much for that, and that's very gracious of you. I think oftentimes we forget to mention the hard-working support team. So we want to thank you for that. If there are no corrections, then I'm going to ask for someone to move. I am assuming you are doing so, Member Guy, seconded
I am Chair.
Seconded by Member Gale, Cavan Gale. So that would take care then. Are there any matters arising from the August 30 minutes? Anything to clarify? No? Or if there's nothing, then I'm going to move now to the minutes of last meeting.
Chair?
Yes.
If I may, at the last meeting, Senator Longmore indicated that there's some matters that she had wanted to have discussed, and I do recall you saying that in light of the fact that the minutes were not being deliberated today, that they would be discussed at last meeting. I don't think they have been, and they could be considered the matters arising, if that is still her view.
Well, she's here, so let's hear from her.
Thank you, Member Guy, and thank you, Chair. And I actually ran here and left the notes, but it obtained to I think, Minister, you had indicated your concern around the spacing, around advertisement near schools, etc. That was one of the issues, and I'm trying to remember exactly what the other issue was. Let me. Yes, I'm trying. No, I ran out and left the notes that I had. Let me just catch myself a minute, Minister, and I will.
Yeah, you may want to refer to page 2 of the October 4th minutes.
Oh,
so let's
yes.
go through it now, and then you can remind yourself there, and then we can pick up from there.
Thank you, Mr.
Right.
Brandon.
Thank you very much. All right, so can we then go to the October 4th, the last meeting, page 1 of 14 pages. Page 2. Page 3.
Yes, Chair. So, page 2.
Okay. All right. You want us to go through confirm and then matters arising?
Okay, great. Thank you.
Page 3. Page 4. Page 5. Pages 6. Seven. Eight. Nine. 10. 11. 12. 13. 'And finally, page 14. 14 of 14. Okay, if there are no corrections, I see no indication of a correction. Can I ask for so moved by Senator Allen, seconded by Senator Longmore? And I think at this point, Senator Longmore, we can now come to you the concern you have, which is stated on here in the minutes.
Thank you, Chairman, and thank you again, Member Guy. Yes, so it is clearly stated here in terms of the consideration around access for minors to smoking apparatus and application of higher fees in that context. And I think the meeting that I had missed, where it was discussed of the delivery service possibility, where persons would take it to minors, and that I think you Minister, have a particular sensibility about that. That would also be in breach of the sale of the product to those individuals. And I am in agreement that there should be a higher fine applicable there. So, I mean, that was the point. There was something else, but I will remember something coming out of the August 30th meeting. Thanks.
What was the decision on that at the time? I don't know if you recall, Mr.
I'm trying to recall myself, Chair. I believe the decision was to have some kind of graduated or higher penalty in such cases. I believe that was proposed in the committee meeting, Chair.
I certainly recall proposing or supporting
Chair.
that position. Yes, Member Guy.
Yes, you are of the view, Chairman, that in light of the fact that children are, we should have special considerations for them. That my recollection is that you did indicate that a higher penalty would be for those persons.
Right. So that was, I think we have some agreement there. So when we begin to do the actual wording, then maybe we can revisit that and determine what that means. Thank you very much for that contribution. Any other issue related to the minutes of October 4th? If not, then I would like us to proceed to the substantive agenda item, which is to go back to our spreadsheet, which should have been distributed to all, and to go through the areas that are of concern, requiring some clarity and conclusion. All right, so that spreadsheet we should all have, and the spreadsheet has the clauses and decisions. I think we would go back to clause 2 at the end because it speaks to, you're right, so I think we had agreed on that. Can we then go to clause 7, policy of the government in relation to tobacco control, subclause 1 and 3, to be redrafted based on the discussion of the committee, and I'm assuming that that was done, or at least an attempt at that. So I'm going to ask Mr. Edwards now to speak to that. Mr. Edwards.
Thank you, Chair. So members will note the proposal. It appears on, well, let me explain what has happened. Essentially, based on the various proposals coming out of the last meeting to adopt the approach, or to adapt and use largely the approach in the Kenyan tobacco control regulations. Clauses 8, 9, and 10 have been reformulated, and the opportunity was also taken to reformulate Clause 7 because of the concerns expressed in relation to subsections 2 and 3. Members will recall the concern in relation to promotional material, and there was also a concern as to the government being being given the responsibility to formulate policy in a rather unusual way in legislation. So what has been proposed is that the subsection 1 be retained, abbreviated somewhat, and subsections 2 and 3 be excised from the bill. So it's a much shorter provision now, which is speaking essentially to the power of the minister to develop a policy framework in relation to, and this will now appear as subsection 1 of clause 4, powers of minister. So what we have done is reformulated clause 7 to be a definition provision for the new provisions dealing with conflict of interest, etc. So clause 4 has been slightly extended to incorporate that policy framework power, which will give the minister the power to prepare a tobacco control policy framework that includes provision for the development and implementation of a national strategy for tobacco control and provision for the protection of the public and public bodies against any undue influence by commercial and other vested interests of the tobacco industry. So we have taken that out of the existing 7, put it into 4, because the other subsections of clause 7 had generated a lot of discussion and concern. So we now have a new clause 7 which deals with the definition provisions for the new framework for conflict of interest and limitation of interaction.
Got you. I'm going to ask now for comments. Member Gale.
I just need that clarification. So yes, what you said you did with 7.2?
7.2 is
State
out.
note, it's out.
Out.
Okay.
And
And
yes,
3.
consequentially.
Yeah.
Yes.
Consequentially,
Yes, so 7.2 and 3 are out. And 7.1c.
Right.
Member Allen, you had a follow-up?
So 7 7 now becomes, so. I
7,
know
7, 7, 1, A and
Because-
B become 4, 1,
Okay.
A and B.
And now we have a new 7.
A new
That
7,
is-
which
okay.
is, yes. Well, what essentially, Chair and members, what we are trying to do is minimize the disruption of the structure of this fairly large bill. So, yes.
Okay, any other comments? Anything,
Yeah.
anything from the, yes, Member Guy, go ahead.
Thank you very much. Just one comment, Chair. In clause 7, where we have some new interpretation for part 3. And I'm just thinking about the quote-unquote untidiness of having interpretations within the structure of the bill as opposed to the usual one where we have it in as the first clause of the bill, or the, in the preliminaries, or sorry, 2, interpretation. I understand the need for it, but I'm just wondering if it could not be addressed in any other way, because it looks a bit untidy, though I appreciate why it is being done.
Mr. Edwards?
Yes, thank you, Chair. Yes, it does appear to disrupt the flow of the text, but it is a device that is used when we want to reserve particular definitions for use in a specific part of the legislation. So it's not unusual, and it will probably look tidier when we have better formatted the document. Thank you, Chair.
Okay.
Chair,
I don't
sorry.
see- Yes, go ahead. Member.
Here's one other matter. Have we gone to clause 8, Mr. Edwards?
No,
The new
not yet.
Oh, okay. All right. Because I wanted to ask something with regards to that.
Once
but,
we get,
I'll wait.
once we get there. Does the
Thank you.
does the SG's office have any comments? And good morning to you. Good afternoon, sorry.
Good afternoon, Chair, colleagues. First, let me just offer an apology on behalf of the Director of Legal Reform, Nadine Wilkins, who is
Yes, we got,
unavoidably. Oh,
we
Ms.
got that earlier.
Wilkins?
Yes.
Okay. No, I thought it was Mrs. Celia Brown.
sorry, yeah, go ahead. Sorry.
Right, Mrs. Celia Brown, I think, had already submitted, but Ms. Wilkins, the Director of Legal Reform, is unavoidably detained. Just to say that, regrettably, because this was circulated this morning and we had other commitments today, we haven't been able to go through. So, but I was looking at what is 4. So I don't know if the committee already finished going through the new clause 4, which was
No,
clause
we're actually on 7.
I thought 7,
1
7 of
and
the
3. Huh?
sorry, not 7 of the bill, which is now 4. Right. So clause 4 in the new
Right.
document. So yes, I do have some comments on 4. Again, I don't like any sort of legislation that's going to talk about a minister preparing a policy framework, because they're saying that the minister is preparing policy. That's a purview of cabinet. There's no legislation needs to talk about the development of policy, because that is an administrative task and it emanates from Section 69 of the Constitution. If we're going to do it, I would prefer if you say that you are just going to go straight into A. Minister may prepare a national strategy for tobacco control. And I don't know how you would phrase B, but to say that the minister is going to be preparing, in effect, policy is, to me, not consistent with Section 69 of the Constitution that says that cabinet is the sole entity that develops and determines policy. Sorry, not develops, but
Okay.
that they determine policy.
So then, first of all, I'd ask 2 questions. Is there any precedent for what is currently being advocated? And second of all, is it conceivable that the articulation of minister is a kind of symbolic application of a process that involves, that is driven by the minister, but clearly requires cabinet discussion and sign off, or would that be?
No, that's agreed. Agreed that when you see minister, usually you can understand that. But
Right.
you don't want anything to look as if you're fettering how the minister, how cabinet, how the executive work. It is left to the executive to decide and determine.
So how would you, okay, got you. How would you rephrase that then so you don't do injury to the concern of the SG while achieving the same thing? Mr. Edwards, tell us quickly.
Well, Chair, we actually had considered existing legislation and looked at the Financial Audit and Administration Act, whereby in recent years the whole reforms dealing with the fiscal framework has provision for fiscal policy framework being developed by the Minister of Finance. So it was that type of model we had looked at, even though understandably, Cabinet is the principal organ of policy, but the power to develop a framework, we didn't see it as fettering the power of Cabinet.
This is my point. I mean, I suspect that it is quite clear that a minister prepares a draft, cabinet debates and agrees and so on, and there's a process. But if what in the wording could you change that would give the minister, because in fairness, the minister represents the, so for want of a better word, the driver of that process. If a minister decides not to, it may never happen. It may never reach the cabinet. So what you don't want to also take away the minister's responsibility, if you will, even though cabinet signs off on these things. How would you reword that?
But therein lies the problem. Why are we putting anything in to almost, as I notice it says may or shall, but is it that you want to place a statutory duty on the minister to exercise this power? Why is this here? Why is it needed? Now, the fiscal responsibility framework, I wouldn't compare with this because you actually have a separate part in the Constitution that deals with finance. And under that part of the Constitution, there are powers given relating to the expenditure and the revenue of the government of Jamaica and so on. This is not something really required by the Constitution. I'm saying that it is not necessary. There is no need for you to put something in about how the minister will go about trying to prepare policy. If the minister doesn't do it, then what happens?
It doesn't get done.
Chair.
And then could we go into the realm of the minister is breaching his statutory obligations? You see, this is why things like this, I don't think have a place in ordinary legislation generally. I know that we may find one or two examples out there, but I am just I have this leaning towards there are matters that are for the executive, they will get done, and they get done pursuant to the process that is understood and that comes from the Constitution.
Right, and I get that, but
Yeah. I wonder, Chair and Solicitor General, if we speak of language referring to propose, if suppose we were to speak of the minister proposing a tobacco control policy framework, which would not suggest as if the minister is making a final determination. But this is really meant to send a signal as to focus, attention on, the scope of what the minister is expected to have as priority in relation to tobacco control. So it's really meant to send a signal externally and internally to the society as to what the one of the primary focal points of the minister will be. I agree that, strictly speaking, the law will not greatly suffer, but I think the optics of this is important. Thank you.
let me hear
So
what
I
Sen-
would support, though, Minister, as I said before, I do not support what's in the chapeau. I would support if the minister is given an obligation, and this is what you're doing, by the way. You're giving the minister an obligation, a statutory obligation to do something. So I'm just asking you and members to seriously consider what you're putting in law. This is not really supported by these chambers, but if you do have to put something in, I can understand if you say that the minister has an obligation to develop and implement the national strategy for tobacco control.
I have no issues with that. Could that be a happy compromise?
It would, Chair.
All right, can you rephrase that for me? But let me hear Senator Allen first. I have no issues with that because I do take the point on the significance of the obligation and the role that has to be played by the executive arm, in this instance represented by the minister, but then ultimately by cabinet. So whether it's obligation or something else, once it's there, I think it sends a signal. So Mr. Edwards, let me hear from Senator Allen, and then I'm going to ask you to just rephrase based on what Senator Allen says.
Thank you, Mr. Chair. I wanted to just, having heard the Solicitor General's views expressed on and the caution that she gave us, I just, prior to the agreement being reached to revise the way in which it is stated, I wanted to just underscore my support for that position because, as you were saying, Mr. Edwards, that it was mainly for the optics or to send a signal, but we want to be careful that in sending the signal, we don't end up in a situation that warrants some revision or consideration later on. So, I mean, that's exactly why we have the SG here to provide this type of guidance and caution. So I think that's pretty well received, and I'm glad it was raised.
I see Member Guy's hand up, and then
Yes, Chair.
Member Gale.
Thank you. My hand had gone up prior to the compromise that was reached by the AG's department, and I'm satisfied and I'm comfortable with that.
And then Member Gale, seems like we have a consensus.
Yeah, and let me just reaffirm the consensus, because when I hear the Solicitor General on more than one occasion on this matter indicating her concern in relation to placing it into a legislation, that, Minister Chairman, is cause for concern. Whilst I can understand the obligation, the concern I would have had is that once you place it in a legislation, if there's any variation of the intended action, then we have to come back here to fix it, rather than a situation where it's a policy. That policy can be varied through the other means of cabinet.
Okay.
Or otherwise.
I think we've gotten it. So let's agree then. Mr. Edwards, you want to reframe that specific language? I don't want to go and come back. I think we should just try and close it. Yes, Ms. Birch. Mike, please. Not hearing you.
It's not on?
Go again.
Hello? Okay. And I would suggest, Minister, in addition to what the SG and other members have said, that it be an obligation where the minister may develop and implement a national strategy for tobacco control, because it may not be a standalone tobacco control strategy. It may be incorporated in the overall non-communicable disease strategy.
So which word is going to create that all-encompassing? The may? Minister's obligation?
The minister may.
May?
Yes.
Are we good with that?
No, Chair, I'm not good with it.
Okay. Go ahead,
Minister,
member.
if we are doing this particular legislation and the minister, you and the committee are committed and convinced that this ought to be so, it cannot be may. It has to be shall. It's a more definitive form of getting something done.
But do you understand? You understand what she was saying? You want to clarify?
I do,
what you were
Chairman,
saying?
but it does not, in my view, prevent anything being part of an overall NCD or whatever other form of thing, because you would have, whether it's part of a standalone policy or part of a general policy, it can be stated that you had done so or the minister had done so. So it has to be shall. Shall has to. If we are going to say that, yes, we are not going to expose the minister to something that might be unconstitutional, as per the SG's comments a while ago about policy decisions and policy, creating of policy. The fact of the matter is that we are saying that arising from this particular legislation or bill that we are doing now, that there are certain deliverables, and there are certain deliverables that have to be tangible. And my concern is that if you put may, there is no certainty that it will be done.
I think you have asserted your point very convincingly. She has nodded in support, so she has conceded. Thank you, Member Guy, for your attentiveness. So, Mr. Edwards, what's the rephrasing of
Yes, Chair. I just want to be clear. We speak about development and implementation. Now, we can speak to both, or we can speak to just the development of the strategy. Do the committee wish to make...
I would think it both, it wouldn't
development and implementation. Okay.
That would be my thought. I don't know if anybody have any objections or alternative views. All right, go ahead. So can you rephrase now?
Okay, so one way to word it would be to speak of the minister shall make provision for the development and implementation of a national strategy for tobacco control that includes provision for the protection of the public and public bodies against any undue influence by commercial and other vested interests of the tobacco industry.
Okay, are we in agreement with that? I see no objection.
No, Chair.
Yes.
We have, I've read somewhere, and I would ask Mr. Edwards to point me to it. The tobacco industry encompasses, by the new definition, commercial, lobbyists, and all of those. So should we say commercial and other vested interest of the tobacco industry? Know that
we could just say, thank you, Member Guy. We could just probably say by the tobacco industry.
By
the tobacco industry, because of the revised definition. I was going on the original definition because we hadn't yet settled the revised definition. But if the committee is accepting the revised definition, then we could speak of just influence by the tobacco industry.
Okay. You want to repeat then the particular line or sentence?
The final, the minister shall make provision for the development and implementation of a national strategy for tobacco control that includes provision for the protection of the public and public bodies against any undue influence by the tobacco industry.
Okay. Are we all agreed? No objections? So can we sign off on that then? All right, so we're gonna for now put that aside as an achievement and progress. I just want to, before we go to clause 8, recognize in the gallery members of the University of the West Indies Fraternity of Roosters. Do you just wondered but allowed whether or not they what do roosters do in the morning again? They wake you up. Anyway, I'm just kidding. This is a Taylor Hall.
It's Taylor Hall chairman.
Members, I know. Maybe you're the one who invited them, member Guy. I'm a chancellor, right, of course, but I respect Taylor Hall. Good to have you, and I hope you enjoy what is an important discussion, and that some of you may end up in here one day, right? All right, so let's go to clause 8, limited interaction.
Sorry, excuse me, Chair.
Yes.
Did the committee agree on the new definition for tobacco industry?
We haven't gone there yet, no.
Oh, but it's on page 2.
No, we had said that we would.
It's just that if the term is being used, then maybe it would be good to just agree on a definition before, because it will impact what is elsewhere.
But Chair, forgive me, but I thought that at the last meeting that we had settled on that particular definition, because there was an extensive discussion on what the tobacco industry was. And if my memory serves me right, we got that from the Kenyan regulation, and we were comfortable with adopting that.
So through you, Chair, what is in the draft is not identical to what's in the Kenyan legislation. So this is why I'm suggesting that you and the members actually just read it and go through it.
My information was that we were to come back with a specific outline of what that definition represented, yeah. So you're suggesting that we should conclude on that?
I'm saying you should actually read it because, for instance, from my perspective, a word is missing from it, and it's not identical to what was read into the record last week. So it's not identical to what's in the Kenyan. It's been tweaked.
Chair?
Yes.
I thank Solicitor General for that point, because in a number of respects, the drafting, with respect, had concerns about the drafting of the Kenyan regulations, not the substance in principle. So I did not adopt wholesale the language because there were a number of issues. In some respects, I won't go into the technical details. So I sought to clarify, avoid ambiguity, because there were in some respects, the language could have been misconstrued. So the language does not slavishly repeat every word of the Kenyan regulations, but it is intended to cover the subject area of the provisions. Thank you, sir.
Right,
what we did agree on it.
We have to sign off on it. That's the thing.
Yeah. We would have adopted the principle.
Exactly.
But you are required to do the amendments to see how those amendments would fit into our situation.
Yeah.
And so I was awaiting your response in regards to the amendments.
Can we just sort of back up a little bit, because I feel a little confused right now that we kind of moving around. But my understanding was exactly that. The question is whether we did it now, before we went through the rest of the information here, as is being suggested by the Solicitor General, or we dealt with it at another point. The Solicitor General?
I wasn't expecting it now.
Right, so this is the point. So what the Solicitor General is suggesting is that we do it now. Isn't that what you're saying? Because it has implications for what we are discussing.
Yes, that was my suggestion.
Exactly. So let's be clear that we did take a decision that instead was it come with a draft. I don't want to spend time arguing the draft or the wording or the nuances of the definition unless we're at that point. The question is, do we do that now or do we wait until later on? What serves our best interest, Mr. Edwards?
Chair, I think it would be very useful to do it now. And I agree with...
Yes, Dr. Guy.
Because it comes in the interpretation, and everything that follows after Section 2 will be based on the interpretation. I think we should do it now.
Okay. All right. So, again, we had agreed that we would have done it later on, but if the members are of the view that it should be done now, may are members of that view, you're kind of changing up the agenda on the chairboard, but okay. If you're at that view, Mr. Edwards, let's go back to it and get that out of the way then, if that will be of benefit to us as we go along.
Yes. Well, we have a definition proposed on the sheet before us, page 2 of the revised suggested text. And maybe through you, Chair, SG could indicate if there's a word, is it a word that is fatal to the meaning of the definition, SG?
Okay. So it's, and I also have a suggestion from the Director of Legal Reform. So it says tobacco industry means persons operating as tobacco manufacturers, wholesale distributors or importers, and exporters of tobacco products, and includes associations, lobbyists, or other individuals or entities representing such operators or working to further their agenda. I think the word persons or other persons working to further their agenda would clarify the last 5 words.
Okay.
The Director of Legal Reform is also suggesting that it should be manufacturers, give me a second, manufacturers of tobacco products and tobacco devices, because we have made those distinctions in our bill. So it's not just tobacco products.
Yes.
Products and devices.
Correct.
Mr. Edwards, how does that reconcile with what your draft?
Chair, I think if we're going to speak of devices, we should probably just speak of relevant products, because the definition of relevant product is where we speak to the devices. Relevant product, you see, we're now starting to go through the proposed definitions, because relevant product is proposed to be defined to mean a nicotine product, nicotine device, or an electronic non-nicotine device. So I would agree that we could speak of tobacco products or relevant products rather than devices, because the relevant product would cover all the devices.
Okay. Are we, Senator Allen, sorry.
Oh, I've gotten a new title, Doctor. Thank you, Chairman. Question for Mr. Edwards. When we say wholesale distributors, are we, and I don't see any reference there to retail distributors, should we just not say distributors, or are retailers not to be included in the definition?
The policy was never to include the retailers, because that's going to make it too, yes.
Okay, thank you.
Can we go back to the issue here with the devices? I want to just close this. Solicitor General, are you comfortable with Mr. Edwards' changing of that word from relevant?
Yes. I just wasn't sure if he was saying tobacco products and relevant
devices.
No,
relevant
relevant tobacco products.
Right. No, I was wondering if he's still keeping tobacco products, or is
Yes.
So you're going to say
Both.
tobacco products
Or
and
relevant products,
Okay.
yes.
That's good?
Yes, I think so.
So can we sign off on that then? That would be a lot of
Yes,
achievement right here. Thank you. That's good. All right. Member Guy, can you take your hand down if you're not commenting?
No, Chair. I mean, I had it up long before you asked. I'd want to make a comment, but that's past the
Okay.
No, I do agree.
Your hand stays up, Member Guy.
No.
It's down now.
All right, I'm going to ask, okay, members, I'm going to ask Mr. Edwards just to ensure for the records that he has it, the accuracy of we're all on the same page. Just repeat for me. Well, it's really state the adjusted definition.
So the adjusted definition would read, tobacco industry means persons operating as tobacco manufacturers, wholesale distributors, or importers and exporters of tobacco products and relevant products, and includes associations, lobbyists, or other individuals or entities representing such operators or persons working to further their agenda.
I didn't hear the relevant. I didn't hear your...
The relevant is in the second line after tobacco products, Chair. Tobacco products.
You read that?
Yes, I did.
Oh, sorry. I've been distracted. All right, so if we're agreed on that, yeah, if you want it, you want him to go over it again?
Okay, so tobacco products means, tobacco industry means persons operating as tobacco manufacturers, wholesale distributors, or importers and exporters of tobacco products and relevant products, and includes associations, lobbyists, or other individuals or entities representing such operators or persons working to further their agenda.
Chair, I know that last bit, persons working to further their agenda, is in the Kenyan legislation, but to be honest, I'm not sure what it means. I'm not sure who these other persons are, because they already have included the associations, lobbyists, other individuals or entities representing the operators. So I'm not sure of that last bit. The persons working to further their agenda is not clear to me.
I don't think it does any harm, though. I mean,
But
I'm not here to make it the legislation wordy, but not worthy. But I'm talking about wordy, W-R-D-Y. But I'm suggesting that maybe you may not think of a other that will turn up. I don't know. I mean, I say we keep it just because it's not doing any injury to the legislation, and it allows us some flexibility around the net being cast in a very changing and evolving period until we're able to revise it over the 5-year period or so.
I am in agreement with you, Chair. I think one of the things that I was considering while we were contemplating this is the transformation of tobacco industry, traditional operators, into other spaces. Like you're seeing now where they're going into asthma medicine development and other non-directly, implicating tobacco agencies. And I think if we kept it with the persons in it, I think it would be useful.
Yeah, I think so. Unless there was some major injury to the bill, I wouldn't trouble it. Thank you very much for that. So can we sign off on that definition then, and then go on to clause 8? Is that all right? Thank you very much. So clause 8 speaks to limited interaction with the tobacco industry by persons who have responsibility for tobacco control. And 9, prohibition on partnerships and endorsement of tobacco industry, acceptance of voluntary contributions. And 10, assignment of duties by a public body and making of disclosure. And the committee agreed on a number of things here. Do I go over this here, or does Mr. Edwards
Question, Chair. Would the committee wish to look at clause 7, the new clause 7, which is proposing various definitions which will be used?
All right, go ahead. Yeah, that would be good.
Chair, I'm sorry, and I hate to do this to you, but I just want to, having situated myself, I was a little lost because I didn't have one of the documents before the committee. I hate this definition of tobacco industry, and the reason I don't like it is because I'm just trying to think in a litigation situation how I would manipulate such a definition, somebody working to further their agenda, what kind. I know we're sort of holding on it for now, but I just want to contribute that I think it still needs a little bit of work, and I don't think it's a committee work necessarily. I think it's a drafter work. So I just commend that to Mr. Edwards, and just maybe if it can be refined in any way, because it is really, when you before a judge and you're having to deal with this definition, it's so many questions that arises from that last line.
Okay, I get you.
The only thing you can think of is to name them, because what I think of here could be possible promoters or marketers, who lead campaign, unless you're going to name them.
And I don't think you want to get into that.
And I don't want to.
If you get into that, you're going to leave people out.
Because it might be too expansive in nature.
Yeah. But listen, I appreciate what you're saying, Member Golden Campbell, but can I suggest, members, that remember now, this is a process, and there are several other stages of this process, including the debate in the Parliament where adjustments can be made. And the periodic, like I said last week, let's not allow good to be the enemy of perfect, or perfection to be the enemy of the good. Otherwise, we'd probably spend a lot of time. But I get the point. I mean, some things can be structured more efficiently. But I think under the circumstances, they should be able to capture what we're trying to do. And unless you have an alternative wording now, because we have to move beyond the principle to the actual specifics, then we probably should hold this until we can move to the next one. All right, so Mr. Edwards, you wanna take us through
I'm so sorry.
7?
I'm so sorry, Chair. I just got another message from Director Legal Reform. So it was agreed to use tobacco products or relevant product, but the relevant product includes a nicotine device. She was, sorry.
Go ahead.
She was thinking of the tobacco device, which is a separate term and defined separately.
Member Guy, could you just turn off, mute your, Member Guy, mute your mic, please. Thank you. Yeah,
So
go ahead.
the term suggested by Mr. Edwards refers to the...
Member Guy. All right. Oh, okay.
Sorry, Chair.
No, it's fine. We understand about the meeting you plan for tomorrow. Go ahead.
Yes.
Go ahead.
The phrase that Mr. Edwards had suggested was relevant product, but relevant product defines nicotine product, nicotine device, not tobacco device. And the suggestion was to include not just tobacco products, but tobacco devices. And tobacco device is actually a defined term.
Right. So what are you?
We're saying that if you include relevant product, you're still leaving out tobacco device.
So we should include tobacco devices?
Yes.
Specifically?
Yes.
So that comes after relevant products, comma, including tobacco devices.
A tobacco product is defined to include a tobacco device.
So you're saying it's already there?
Yes.
Okay. Do we agree to that? I am of that impression too.
Yes, I've seen it. I'll advise the director. Yes.
Okay. Excellent. All right. So Mr. Edwards, go back to where we were then on clause 7, using the current definition, please.
Will you propose definitions, Chair?
Yes. Yes.
Okay, thanks. So what I would say, to maybe make it a little easier, is that the definitions of parliamentarian, public function, and public official and security forces have not changed since the earlier proposals that the committee has been considering. So the new definitions are those of appropriate public body, interaction, and interaction. So appropriate public body is defined in relation to a public official to mean the public body that the public official is employed to, contracted to, or otherwise serves in. And the relevance of this is that we're going to see further down in this revised part, or proposed revised part of the bill, where reference is to be made in a number of circumstances to the public officials, the appropriate authority in the body where the person is connected to, or with which the public official is connected. So that is why we are proposing a definition of appropriate authority. There's also a proposal for defining appropriate public body, because there's also provision being made for circumstances where reference has to be made to the body that the official is employed to, contracted to, or otherwise serves in. So that's why these two definitions are being proposed. In the Kenyan model, the Kenyan regulations spoke to relevant in a number of cases, but where is it used? Okay, so for example, to you, Chair, Member Golding Campbell is asking where the terms are used. So if we look at clause 8, we will see before commencing an interaction, clause 8.3, for example, before commencing any interaction with the tobacco industry, a public official shall state in writing to the appropriate authority that the interaction does not imply an endorsement of tobacco industry practices, etc. So there are a number of areas in these provisions where reference is made to the public official's appropriate authority. So that those are two definitions being proposed, Chair.
That 8.3 was a semblance of that present in the Kenyan.
Yes, it was. That is coming from the Kenyan legislation because we had never required this level of activity. So,
I've asked you to point me to it, Mr. Elders, on the basis of the use of appropriate authority. I'm not convinced that we need to have this additional appropriate authority definition, but having said that, before a public official has any interaction with someone in the tobacco industry, they must state in writing to the appropriate authority, and any interaction, it must be defined, yeah?
Yes, interaction is defined. Interaction is defined. The philosophy underlying all of this is that there's not to be any, in this context, there's not to be any casual interaction. These activities must be planned, prepared activities. You must have at least one other person with you as a public official in these activities, whether it be meeting or other exchange that is happening between you as an official and members of the tobacco industry.
Where's our interaction definition? Wasn't in the original bill.
No, it wasn't in the original bill, but it was in the text of provisions proposed some weeks now. So it's on page 7 of the document before the committee members. Interaction means a meeting.
Okay. Thank you.
Member Guy, you have your hand up.
Yes, Chair. I want Mr. Edwards to explain for me, would I fall afoul of the law if I have a friend who works in the tobacco industry? I'll be one of those persons who would be a public within defined as being in the public, a public body, because I'm a parliamentarian. And my good friend works with the tobacco industry, and interaction with him, having drinks and so, would that be considered going against this particular bill, or this act if it becomes a bill, if it becomes a law? Can I have some clarification there? Because it would mean, therefore, that I'd have to stop being an MP or cut off my friends.
And that is not being contemplated, Chair.
No, but whether it was contemplated or not, is it based on how it is put here? Would that fall in the category?
Only if you're meeting in a business context, because interaction is not just a casual meeting of persons or casual encounter, but it is
motive.
Pardon me?
It's about motive.
Yes. When you meet with the industry in a, well, the language of Kenya was business forum. So we were trying to invite the committee to settle the language there.
Why don't you say that explicitly? Why don't you just say it explicitly rather than leave it to an assumption?
In other words, defined if there's an intent as to why we're meeting. Because member guy is right. He could go to his normal rum shop in Highgate.
That's a business forum?
Eh?
It could be.
From with a
It could
business
be.
place.
Okay.
But we just have to be clear
Well,
that there may be a specific intent or purpose for the interaction. And if that could be incorporated in the definition, if that is also possible.
It is, Chair and members. We could go further, drill down further. But we have to be careful not to be too...
Well, intent or purpose sounds also vague. I mean, intent or purpose for the propagation of business. Because the intent or purpose could be to relax or to enjoy each other's company. So I think we're trying to keep it clear that it is the propagation of business, of the industry.
But isn't that sort of captured elsewhere, Mr. Edwards? If it's captured elsewhere in the bill. The association that generally we would want to know about or discourage is an association to promulgate the interests of the industry. I think that is fairly explicit somewhere.
Definition, Chair, speaks of interaction in the context of a common business forum. Now we can speak of common business forum in relation to tobacco interests if we want to be...
I think you should do that because I think that would be a lot more explicit. The truth is a lot of deals and business interests are not done in a sort of formal business context. People do it on the golf course. They do it. So, I mean, you may want to make that a bit more specific, I would think. I don't know if anybody else has an opinion on it, but that would be my...
Will do, Chair.
All right, so are you able to formulate that so we can...
I would like a little time to just turn it over, Chair.
All right. Yes, Madam SG.
Yeah, just to say, because Mr. Edwards had put common in square brackets, and I think I know why, because it came from Kenya, but even in the Kenyan legislation, I really wasn't taken with it. Not sure what it's intended to mean. Would we lose anything if we delete common and we talk about this business forum, which will be drilled down even further? Because
I think,
I'm not sure what the common is being.
Yes. So yes, SG had the same, hesitation as I did, Chair. So once we drill down with a little more detail, we can take out the word common. Yeah.
Just to also point out, Chair, the term appropriate public body is not used anywhere else. At least we can't find it. We were doing a search. So public body is defined already in the bill. Not sure that you need appropriate public body.
Could you say relevant public body?
No, meaning the term isn't used at all.
Relevant public body?
It's not used either. I looked for that.
Oh, yeah?
What is used is public body.
Public body.
Which is already defined in the bill.
Okay. All right.
The intent, though, Chair, was to use the term appropriate public body in some cases to tie down the body to the public body to the particular public official. So I'll just review that, Chair. Thank you. Thank you, SG.
What you're saying is that where you have public officials might be spread right across the public sector, but you want to make it specific to a public official in relation to the tobacco, the authority. No, Chair. To Senator Gale. No, it's that the intention is to ensure that when we speak of the duties of the official in relation to the public body, we're speaking of the public body that the person is employed to or connected with. So that's why we use the term appropriate public body. That was the intention. Between the public official and you said the appropriate public body. But it has to be a little more specific in terms of what is that appropriate public body that you're speaking of. You have said in for relevant public body or appropriate authority.
All right, I'm just going to find.
Isn't public body?
Yes. Okay. Yes, thank you, thank you, Ms. Birch. Yes, 9.1 is one of the provisions that we had intended to use the term appropriate public body. It still has the word relevant there, but that should be appropriate. So, to assist Senator Gale, so the third line of clause 9 on page 10 of the list of provisions speaks to the public official who has an interest, whether of a pecuniary or business nature, in the tobacco industry, shall disclose the nature of the interest to the relevant public body. And we had wished to use the term appropriate public body to make it very clear that the disclosure is to the public body with which the official is connected or employed. So that should have been appropriate. That was a carryover from the Kenyan language, but we would have preferred to use the word appropriate instead of relevant. And it's also consistent with other legislation dealing with conflict of interest, and rules speak of the appropriate authority, or, as opposed to the relevant authority.
All right. So you're actually still going with the term appropriate.
Yes.
Despite the comments from the SG, okay.
No, the comment from the SG was correct in the sense that she and her colleagues hadn't seen the use of the term in the body of the provisions. Okay. So what we're saying is that we really just needed to amend 9.1 to redefine relevant public body as appropriate public body. Chair.
Okay. All right. So do you need to read over anything there now to get it clear, or I think we're good on that? Anybody? We're all clear? Okay, can we move to... Continue, Mr. Edwards, sorry.
So we've spoken to the two definitions, appropriate, and then the definition of interaction. We've agreed to give some more detail to tie the activity, the meeting activity down to the business, tobacco business. As I said here, the other definitions had already been on the table for some weeks, so I don't know if I need to go through those. Maybe we can now go to the substantive proposed text in 8, which is the revised provision dealing with limited interaction with the tobacco industry by a public body or public official. That is so, Senator Allen. It is a new 8. Mm-hmm. And the idea throughout this part is to incorporate the provisions of the Kenyan regulations as far as, should I say, reasonably practicable, and then without losing the substance of what we had before. What we had before that was not offensive to the committee. So,
but the reason, I'm sorry for interrupting. Mm-hmm. The reason we are looking at a new 8 and 9 was because of the intervention or the suggestions in the letter from the SG last week, right? It was a recommendation to replace. So based on what has been presented by you to us here, including the SG, would we? What is the position of the Solicitor General on this new 8 and 9?
May I comment before the Solicitor General does? To be fair, because these provisions were circulated only early this morning to everybody, including the Solicitor General. Yes. Yes, but essentially what I'm saying is that they take account of every provision of the Kenyan regulations that was commended to us, but of course the commendation by the Solicitor General of those provisions was subject to us adapting them appropriately to our legislative scheme and so on. So the first provision is subsection 1, which speaks of a public body or public official. We have a may or shall, and I didn't want to settle on that without bringing it to the committee to consider the implications of using either term. So we have a public body or public official may, or a public body or public official shall only participate in interactions with the tobacco industry to the extent strictly necessary for effective tobacco control and enforcement of relevant laws.
You have terms like strictly necessary. Why would you want to use may? You should use shall.
Thank you. So we have noted. And
Chair, if I may, not on the
Go
may
ahead.
shall point.
Huh?
On the last, not on the may shall point. In relation to the last 5 words. I'm not sure enforcement of relevant laws. I know it was in the Kenyan law, but I don't know. So if when we talk about relevant laws in other legislation, we usually identify them. I'm not sure which relevant laws this would be, and to be honest, I'm not sure that you would lose anything if you deleted those last 5 words.
And we agree. We agree, yes. We are happy to remove. Yes.
All right, Mr. Edwards, continue. We're
So
an hour and a half
subsection-
into the discussion, and we probably haven't made as much mileage as we would like.
Subsection 2 provides that a public official shall not participate in any interaction consisting of a meeting with the tobacco industry, except, and again we have up 2 formulations, except in joint participation with at least one other public official, or except in the presence of another public official.
What's your thoughts with the difference?
The difference is that in the first case, we're speaking of a more active activity
So this
involving 2 persons.
So this is dual accountability.
Dual accountability.
In the first instance.
Yes, which varies a bit from the Kenyan position, because the Kenyan regulations just basically said 2 persons had to be
Yes,
together.
yes.
But it did not speak of them acting in any concert or jointly.
So the second one could be your administrative assistant.
Is in the same room with you.
Right. So I'm just trying to understand if your focus is to call for dual accountability.
It is, because other than that, the mere fact that you have another public official in the same space with you doesn't suggest that the person even knows why you're there. Indeed. So, from the ministry's perspective, we prefer the first formulation, but it's just that the second formulation was more akin to what was in the Kenyan regulations.
Okay, any objections, any comments? If none, proceed. I'm assuming that we are accepting. Yes. Okay, Ms. Edwards, go ahead.
Thank you. And then subsection 3, before commencing any interaction with the tobacco industry, a public official shall state in writing to the appropriate authority, the defined term, that the interaction does not imply an endorsement of tobacco industry practices and that no relationship, collaboration, or partnership whatsoever shall be construed as arising from the interaction.
I had asked last week, I can't recall the answer that I had received, if this correspondence required a response.
I had responded to you, through you, Chair, to you, Senator Gill, to say that based on the legislation, it did not require a response, based on how it is framed.
How would you know that the sending of this memo could not be
don't.
subject to manipulation where it was never received and therefore.
You don't. And there's no requirement that there is acceptance or agreement. There's nothing, it's a bald statement.
Is that a
so to
loophole?
speak. I think it is. And that's what I had said last week as well.
So what would we need to address that injury? Should we say a response within 21
You
days
see, I think
or
it looks at
something like that?
I
Huh?
think it depends on the intent. If the intent is just for the public official to know that they, okay, it's supposed to provide coverage for the public official. Perhaps it is something that the public official would want to just put on a file. So, you know, you have a file that you have about these meetings and you put it on the file that I made this statement. I just think the coverage is not complete. I think it should go on to say that it should be conveyed to the person you're having the meeting with, and that person should indicate even receiving it. They don't have to accept it, but just to receive it.
No, I get the point, and I take your point.
You see, Chair, I don't want it to be viewed as just a declaration without some response that the other party would have at least received it, so they become aware.
So, Mr. Edwards, how would we adjust to accommodate that?
Well, we'd have to make provision for
An acknowledgement.
acknowledgement. But what would be is it that nothing happens before? You see, we have to think. So, what's the effect of the waiting for an acknowledgement? Is it that if you don't have it acknowledged formally, you cannot enter into the interaction?
I think that is the implicit assumption. Yes.
Okay.
But you see, the other party who you're sending this to, they would want the interaction to take place, you assume. And so, the resultant effect to you sending it, at least acknowledge. And I'm not going to start talking with you until you acknowledge receipt of this.
This is a talking outside of your organization, you know.
Yes.
So, all right. So we will make provision for the written notification to be acknowledged, and that should happen prior to the commencement of the interaction. Okay.
That's a relatively simple amendment.
Yes.
So you want to just read it out for us?
Okay, so what we have now is before commencing, the public official shall state in writing to the appropriate authority that the interaction does not imply any endorsement, etc. And the you see, we can't put an obligation on the authority to receive it.
I don't know if logistically it is that difficult. If you
Chair, could you just allow us to the next meeting, because it's something we can also try to assist.
Thank you for agreeing to assist, SG. That's very nice of you. I think Mr. Edwards and yourself should meet a little more frequently to to cut down on the on the dissension during the discussion. No, that's appreciated. So, Mr. Edwards, you're getting an offer there, which I think you should accept. Can we move on then?
I definitely accept, Chair.
Move on.
So, subsection 4 speaks to a public official participating in any interaction with the tobacco industry shall prepare a formal record of the interaction and submit it to the relevant. Here again, it will be the appropriate public body. or the appropriate authority on request.
Okay, that's pretty straightforward. Any objections? Yes, Paho, Mr. Stein.
Only on request.
Well, let me hear Mr. Stein.
It
Yes.
was actually that, thank you very much, Mr. Chair. It was actually that particular issue. The words on request, I think actually should not be there. I think that actually the guidelines of the Framework Convention also, for transparency, requires this to be documented each time.
Okay, so it shouldn't be on request. It should be,
You could actually strike those two words.
okay. Any objections to that?
Chair, could I have the reading of it again,
Sure.
as Mr. Stein has put it now?
Right. Well, first of all, any objection? I don't hear any. So, Mr. Edwards, could you correct and just read?
So the question, though, Chair, is that are we speaking then of preparing a record and submitting it to either the body or the authority? Because I was wondering if the part about the request was only in relation to the appropriate authority.
Yeah, I also thought that it related to the appropriate authority,
Yes,
but I
yes.
think
Uh-huh.
the question has now raised an issue that it's not clear.
Yes.
So perhaps we would have to switch the words on request so that it is clear that
It is
as
clear.
it relates to the request, it's only on the part of the
The
appropriate
the
body.
That's right.
I mean, appropriate authority, not the relevant public body.
Okay, so what does that mean? Are we going to strike the two words and rephrase?
Well, I have been interpreting it differently, that the obligation was to submit to, based on Mr. Stein's contribution, that the obligation to prepare the record and submit would always be in relation to the appropriate body, to your organization, and in relation to the appropriate authority to be on request.
So, Mr. Edwards, and you know I'm not a drafter, but could we say or on request to the appropriate
That's right.
authority?
Exactly,
Oh,
that
okay.
would make it clear.
Please.
So it would say submit it to the relevant public body or on request to the appropriate authority.
What it
I
does
think
is
we have
that
to be
it compels.
and on request, not
sorry,
or.
and
on request.
and on
And on
request.
request.
So it compels
You
for the
always have to
relevant
submit
public
it.
body to have
Yes,
the record.
You always
That's
have to
right.
submit
I'm
it.
fine with that.
But if the appropriate authority wants a copy of what you prepared and submitted, they could make that request. And you would then
Okay.
provide it to
I
them.
agree with that.
Yeah.
I agree with that. So let's do it that way then, Mr. Edwards.
Yes.
You're going to read it over for
Yes,
us?
it would
or-
read, a public official participating in any interaction with the tobacco industry shall prepare a formal record of the interaction and submit it to the relevant public body and, on request, to the appropriate authority.
Okay, I think we have a consensus around that. If that is the case, Mr. Edwards, move on, please.
So subsection 5, a public body that initiates an interaction with the tobacco industry shall ensure that the interaction takes place only in a public venue determined by the public body. Again, this is not exactly how Kenya had stated it, but we rephrased it because we thought it was clearer this way.
Was there a,
So,
was
Mr.
there,
Edwards.
was there a definitional issue with that, what the public body,
Chair?
public place? Yes.
So in this, as Senator Gale had said earlier on about my drinking spot in Highgate, I could apply for that to be determined by the public body and then meet whomever there.
Except that you're not a public body with respect, Member Guy.
You're a public official, not
You're
a public body.
official.
I'm sorry, Chair,
No, go
through
ahead.
you. I'm trying to understand the rationale behind this one. I mean, if the interaction, as it's defined, can only take place in relation to the public official with that other person acting in concert in terms of their presence and purpose there, and if it has to be on record, What's the rationale behind whether it's a public venue or a private residence? Help me understand. I don't see how that furthers transparency, to be honest.
I think the intention is to put control in the hands of the public body, as opposed to a tobacco manufacturer or other industry member saying, let's go to so-and-so hotel down
So
the
why
road.
not just say it must take place at a venue determined by the public body? Just, it must be determined by the public body. Whether it's public or private, it must be determined, whether the venue, you would call it public or private, it just must be determined by the public body. So if the tobacco industry wants to have a meeting with the minister, then the minister and that other person who is present, at least, the Ministry of Health is who will determine where that is. And you, yeah. I don't see the rationale behind the public venue restriction. Not certainly on the basis of just control.
All right, well, we'll see that subsection 6, which follows immediately, speaks to the fact that there are going to be cases where, there are going to be situations where the interaction does not take place in such a venue. Mm-hmm.
Any other comment on this? Well, I'm trying to get any additional feedback.
Sorry, Chair. I'm just a little bit sorry. I'm lost. Could you just read back that section, please?
Subsection 6, interactions, subsection 5, a public body that initiates an interaction with the tobacco industry shall ensure that the interaction takes place only in a public venue determined by the public body.
Okay.
Again, we were trying to align ourselves to the language of Kenya because the ministry doesn't really see why it has to be in a public venue. It could be a private location. But the important thing is that it's determined by the public body.
Yeah. Yes, I think I'm in agreement with Senator Campbell.
In a venue. I think if we take out the word public before
the
venue.
location is not necessarily, it's the interaction between the individuals that is relevant. And
it's the control of the venue.
Yes, yeah.
Let me hear what Mr. Stein has to say.
Thank you, Mr. Chair. I think that the intent here is actually to address the issue of perception and the guidelines, and allow me to read the guidelines of what they say on this particular issue. Where interactions with the tobacco industry are necessary, parties should ensure that such interactions are conducted transparently. Wherever possible, interactions should be conducted in public, for example, through public hearings, public notice of interactions, disclosure records of such interactions to the public. I think that the intent here, as I say, is to remove the perceptions that these negotiations or discussions are happening for the intent of the industry itself. And so this is what the guidelines are suggesting.
But we have indicated in what has been proposed thus far certain declarations that need to be made before any meetings take place. And so whether it is a private space or not, the space or the meeting would have to be declared by said public official or that body. So I don't think we need to have it in a public space. It can be anywhere once you follow the other guidelines. And if you don't, then there are ramifications, or,
Dr. Guy?
Chair, thank you. I see we use here public venue, but in our interpretation we have public place. And the question is, why not conform to what we have there? And the definition of a public place means any structure, facility, place of assembly, or other place available to use collectively by the public, including a government office and space or building of any type regardless of the ownership of or right of access to any such place, office space, or building. So if we just stick to a public place determined by the public body, I think we're okay.
Chair, this is dealing with a public place in this situation. Member Guy is dealing with a different context in terms of where you might not want smoking taking place. But it I don't believe it applies.
No. The interpretation for this act of a public place, whether it's for smoking or otherwise, is a general conformity. Has to be. So why you're going to have a public venue and a public place? Why not have the same?
Member Guy, can I try? Because I think the distinction that Senator Gale is trying to make is that there was an intention in using public venue not to capture the definition of public place, but I think to capture the idea, well,
public as opposed to private.
Right. And so the question that I raised was, what difference does it make? And I'm going to say it in this context, Chair, that I have seen in my time public officials, ministers and prime ministers, hold business meetings while they're supposedly trying to be on vacation. Take a couple days off. Of course, that doesn't actually happen. So they may go to a villa, for instance, which would not be considered a public venue in the sense of this open place, but they're actually holding business meetings there. And so I don't think it is useful, and I hear what Mr. Stein is saying in terms of the guidelines, but I, like Senator Allen, and I join with her in saying this, that I think the protections that precede this are sufficient to permit us to remove that and simply to ensure that the control over where the meeting happens resides with the public body. And then if we do that, that control, of course, is also restricted by the subclause after, which prohibits interactions taking place at facilities or offices of the tobacco industry, and that includes owned by, rent by, whatever. And I will say one more thing further, that please remember that the interactions are not only about discussions and business meetings with the tobacco industry that are intended to further the tobacco industry, but also those interactions and discussions, perhaps of the minister seeking to encourage the tobacco industry to take a particular course in terms of promotion of health or in terms of facilitating better health practices. And sometimes when you talk about a public venue, when I hear you on the guidelines, Mr. Stein, it is useful when you can have those conversations in a place where all parties can be frank and open and fully disclose.
Sure.
Okay, this is...
I have a concern.
This is engaging our minds here. Let me try and be orderly in terms of Dr. Longmore, then I'm going to go to Ms. Birch, and then I see, okay, Senator Allen.
My consideration now, having heard what Mr. Stein has said, I think, a lot of these companies, and as Senator Golden Campbell indicated, it could be opportune that it is an ostentatious occasion or a very relaxed atmosphere that puts someone in a more favorable mindset to the business that is being discussed. And this is a strategy that can be employed. A public venue determines a particular decorum, a particular space and process of interaction that keeps it objective. And I think for the whole premise of this piece of legislation is to, as best as possible, protect persons from the predisposing behavior of the addiction that comes with this product. And so I think that we should always err on the side of caution where the public's interest is kept paramount and the discussions around business that may impact on this interest is kept as clear and as open as possible. So I have an inclination to recognize what Mr. Stein's input is, in that we keep it as a public venue that such operations happen.
So you're going back to the original position then? Okay. Yes, Ms. Birch?
Thank you, Chair. I wondered, Minister, in hearing the reading of the guidelines, section 2.2, I'm thinking that the objective is not so much where the interaction takes place, but the objective is to ensure that they are conducted transparently. We have, in the provision provided, it specifies public venue, but given the discussion that is taking place, if we could consider, Mr. Edwards, how we could frame this provision so it captures the principle that the interactions are conducted transparently, whether public venue or private venue.
All right. You're saying that has been done?
Yeah.
Go ahead,
yes.
Senator Allen.
Thank you, Chair. I believe I'm in agreement. I just wanted to underscore something you said earlier, Senator Golden Campbell. If we are here to do the work and do justice to it, we must also look at the fact that it's not just a legislation, a piece of legislation that is going to just prevent. It also should facilitate. And I believe that the guidelines, I still stand by the point made earlier, that the guidelines, once are adhered to, are sufficient, that the meeting does not have to take place in a public, but that the meeting is transparent, or what takes place is a transparent process. So I don't need to see, and I appreciate the guidelines provided, and guidelines are what they are, guidelines, but I believe that it is sufficient based on all the other provisions to simply have the meeting, not necessarily public or private, but right.
So, yes, Mr. Stein.
Thank you very much, Mr. Chair. I think that I respect what we're talking about on the public versus private location, and I also respect the fact that there's many discussions that take place on a range of different government policy negotiations that might take place in the range of different types of venues. Allow me to just mention two things. One is we're talking about the tobacco industry and tobacco legislation in particular here. So I don't want to carve out that space in general. I think that we're talking about a very sensitive matter here of where these discussions take place as it relates to tobacco. And I think the reason why I raised that is because of what I first said in my first comments, is that the intent here is to remove any perception of conflict. Because the public perception of a discussion taking place in a private venue could allow someone, the public, to perceive that there is something taking place that's a little bit more nefarious. And as a result of that, I think the intent there is to have it in a public venue.
Mr. Edwards?
I was just going to suggest, Chair, if we could add a few words to subsection 5 that may give a little flexibility without taking away the essence of keeping it transparent as far as possible. If we add the words as far as practicable after ensure, so it would read, a public body that initiates an interaction with the tobacco industry shall ensure as far as practicable that the interaction takes place only in a public venue determined by the public body. No, but it's
I
put
think
an
what you're doing
obligation.
there is it's tantamount to saying that you don't have to have it in a public.
No, but the words
Chairman.
as far as practicable mean that you have to consider. It's not something you just pass over. It's not something you just pass over. But it could end up being very impractical if we say it only has to take place in a particular type of venue.
Chair, if I might.
So it may not take place.
I'm sorry, Mr. Edwards, if I might. Because we're talking about transparency, which is what fosters a positive public perception. I simply don't agree with you, Mr. Stein, on this one. I think that we have put in some pretty unusual and strong protocols in requiring that public body to not be able to be in a meeting without an additional person, in requiring that public official to give, is it notice? I'm using that loosely.
Notice, prior notification.
Prior notification before the meeting, and then creating a formal record. I think that's a sturdy system in terms of transparency, and I simply don't support the idea of removing from the public body the ability to hold that meeting in anywhere convenient to the particular public official, which may not be a public venue. I've seen the life of these ministers, and they're all over the place, morning, noon, and night, could be in several different parishes at a time. It's helpful if they can do things in a way convenient to executing their duties, and I would like to leave that freedom to the public body to be able to determine that.
Chairman, if I may, let us look at it at another angle. I can't see why we would want to leave this possibility there. And if we were contemplating whether or not this meeting should occur at the National Chest Hospital, where the cancer patients are, would we invite the members of the industry to have our meeting there to see the actual effect of their product versus somewhere that is quite ostentatious? The fact is that there is an association, and there's a use of a psychological association with the positives that these companies use to get their agenda across. So if they schedule a meeting in a lovely villa on a beach somewhere, your human tendencies for you to be more inclined to that whatever business and to respond in that way. It is a way that persons get what they want. It's the power of advertising. Now, I said, the flip side to that is, why not have it amongst the persons who are dealing with the consequences of their product?
All right, can I come in here? I've heard a lot. Mr. Edwards, what is the standard clause in types of legislation of this kind as it relates to where these meetings should take place? Is there such a thing, or is this kind of new ground that we're breaking?
Sure, I don't know if I'd say there's a standard. This is really quite unique, this legislation.
So it's not a.
No. Oh, I was speaking in the context of tobacco as opposed to other areas of law.
No, but I'm talking about other types of other pieces of legislation around tobacco control. Is there a clause that expresses a view around meeting in public spaces, or?
There's a general obligation to maintain transparency and accountability in relation between the industry and the public sector. They may not go into this level of detail as to where you meet and what type of place. I think Kenya is much more detailed than some others.
I'm just wondering that the issue of if we decide to go and have a meeting at a hotel in Kingston, and we rented a room, which is a public entity, but the room clearly is relatively private. What would be the most important consideration in transparency? outside of the meeting place, would it be that the records are the minutes of the meeting are recorded and lodged in a place that can be examined later on, or I'm just trying to determine whether or not. Yeah, go ahead.
Chair, with respect, that is where we separate transparency and accountability, because I think what Senator Golden Campbell was speaking to is accountability, or the record keeping, which most people are not going to know about anyway. Most people are not going to know that you wrote to the head of your organization to ask for permission. Most people are not going to know that.
On a point of order, Mr. Edwards, let me correct the record, because it is not just about accountability. It's also about transparency. Because prior to this meeting, I'm required to notify that the meeting is happening.
You're just notifying your boss. Well, I'm saying that's accountability, but the transparency.
Hold on, Mr. Edwards. Yeah. I'm then prohibited from attending that meeting alone. I can't attend that meeting alone. So there is another person in the public system or persons who are present, attending, hearing, and observing all of the discussion and the interaction that I as a public official am having. That is the layer of transparency that I think is the biggest one. Not so much the notification or even the record after, but the fact that I am there with 1 or 2 or 3 other public officers, let me call them that, because they may not be defined as public officials, is what is the transparent part of it. It means that I can't have a private meeting with the tobacco industry.
But
might I add something to that, Mr. Edwards, before you respond?
Can I just hear this? I'm going to come back to you. Let me hear what the Solicitor SG is saying.
We are forgetting a very important tool in our Jamaican legislative landscape, the Access to Information Act. You would be very surprised how persons utilize that law. Even in my office, we get ATI requests, and that act, the objects of that act are all about transparency, about how government interacts and does its business. And under that act, requests could be made of any public entity about their interactions with the tobacco industry. And especially after this law is promulgated, you better believe that that will more than likely happen, because persons will look through, especially special interest groups, you'd be surprised, they will look through the law, they will realize that there is supposed to be transparency and accountability in terms of how meetings are conducted. They will see that the law requires that records are to be kept, and so what they will do is put in an application under the ATI Act for a copy of those records. So I think we should remember that we're not doing this in isolation, but it is part of our legislative landscape.
You say that to say what? That
you don't need to say whether the meeting is going to be in public or not, and that the transparency will be achieved not only by what precedes the subsection 5, but what is thereafter in subsection 6, and the fact that you can also achieve transparency using the Access to Information Act.
All right, so I think we're evolving into a consensus.
No, Chair. No, Chair. Sorry. Thank you. And I'm gonna make sure that as clearly it is being recognized, that my opinion and and I hope that it's fully expressed, differs here, because that is not. I don't think that is what, if I'm interpreting what Mr. Edwards is projecting, is not the objective. I think we have all mechanisms in place to ensure transparency. There is absolutely no question that there is a psychological association with the location of a meeting. To the person who is involved, like I said, my question is, why are we leaving it open to have that possibility of a positive light being, or a kind of a nicely polished presentation when in reality there are consequences to the nature of this business that are not as polished, that are not as pretty. And we are to seek to protect the propagation of that business that leads to the not pretty side of this of the consumption of the product. So in my mind, it is critical that we protect as best we can and ensure that yes, there's transparency, the Integrity Act, all of those are there for us to access the Information Act is there, but I would want for us to keep it and such meetings in a public venue, and it remains standard that there is no play that the industry can take advantage of.
Okay,
Thank you.
So can I just, we're going to try and conclude this session at 4:30, if that's okay with everyone. Normally we do 2 hours, we'll go 2.5, right? So I hope we'll, oh, you can go on to 5. Okay, fine, that's good.
No, Chair, I can't go to 5.
Not 5, okay,
I'm
4:30.
banking on your usual 2 hour.
Right, we're going to go a little extra because you were late, Dr. No, not you, sorry. A few others were late.
Talking like the speaker now, Chair.
No, but seriously, no, let me just, we need to wrap this up. And again, remember, no, there's going to be a basis on which these things can be reviewed, okay, at different levels. So we just need to move forward. I think the injury which is being attempted in the case of the proponents of the public body requirement is to give the perception of transparency, not to actually achieve in its strictest form transparency, because the other requirements around record keeping, access to information and so on could and would, if necessary, achieve openness of content. So I think it's more a perception issue, which has its value. I think those who say it's not necessary is not arguing on behalf of the tobacco industry. It's really on behalf of the public officials who I am interpreting Member Golden Campbell correctly. She's saying that they should be given at least the leverage to be able to carry on their responsibilities in the context of a busy schedule. And I suspect she should know more than any other how busy public officials can be. And therefore, they should not be restricted. So let me be clear that this debate is not in any way on any side proposing any advantage to the tobacco interests. The issue is how we achieve the goal of regulation, at the same time the transparency and accountability that we seek. Can I tell you, I believe there are advantages to both positions, because on the side of the perception of transparency, I'm a big believer in that as a person who believes in communication and perception management. On the issue of the public official, I think there's value there too, except that restricting even the public official to a particular format may actually serve the interests of the public official's fiduciary responsibility more over time, because the fact that you have to structure and plan a discussion around this particular industry may mean in practical terms that on your vacation you don't engage that kind of conversation. Who knows? Maybe you might be so relaxed that you make a few slips there in terms of some of the judgment calls. I'm just saying that that's not necessarily going to be the case. In other words, you may have to comply more rigidly to a format and at the same time achieving the perceptions of transparency. I don't know if you understand what I'm saying. All right? So from that standpoint, I am inclined to say that maybe we should maintain the position around for the time being, around the need for a public place, even though substantially it doesn't achieve the transparency and that should not be the argument for it. It has to be an argument for perceptions of transparency, not transparency itself. So if we agree, hold on, I'm giving my opinion. I think I'm entitled to it, right? If we agree that the perception of transparency is necessary, then that may be the way to go. But as I said, there are advantages to both. So that's my view as a chairman. I guess I'm supporting Dr. Longmore, Senator Longmore, but I don't know what Member Guy has to say. Maybe he can have the casting vote, given that he would represent the weight of majority in this case. Member Guy, what's your view?
Chair, I think, quite frankly, we could go along with this as is crafted here, right? A public place, the perception is important, and I think the transparency it also should be determined, as we have said, by the public body, but in a public place.
All right, so...
Sorry, Chair, then I think you have to revisit the words public venue. Earlier, somebody spoke about, a member spoke about a meeting, I think, in a hotel, and then if you go into a room, there could be a major argument about where is the venue? Is the venue the hotel or is the venue the room? I'm just saying you'd be surprised that people would then want to split hairs because of this kind of obligation. So then it would need to be very clear what you're allowing and what you are not allowing.
AG, you're saying the lawyers would want to split hairs?
No, but the lawyers split hairs because of the challenges they face in the courts. But Chair, if I might, I just want to go back to this question of the guidelines, right? Because the guidelines that Mr. Stein read out, and if I'm looking at the same one, that would be the recommendation at 2.2, where interactions with the tobacco industry are necessary, parties should ensure such interactions are conducted transparently. And the guidelines speak to whenever possible, interactions, whenever possible, interactions, I'm going to read that again. Whenever possible, interactions should be conducted in public, and the example given is through public hearings, public notice of interactions, disclosure of records of such interactions to the public. With respect, that is not the scheme that we have adopted. That's not the scheme that we have adopted. We have taken a different approach, and the approach we have taken is to permit a meeting between a public official and the tobacco industry that has certain checks and balances associated with that meeting, for that meeting to be made public, the disclosure of that meeting to be made public, and for notification to be given prior, etc., etc. So we haven't gone this route of a meeting or interaction must only take place in a public meeting. The example of which is provided here is a hearing, because we contemplate, I believe, that a meeting between the tobacco industry and a public official is not necessarily one that is appropriate for a public hearing. That's a public meeting, and that's a different thing. So I just want to say at the end of it, Chair, notwithstanding what you have just said and what Senator Longmore has said, we really have taken a different approach to how this goes, and therefore I still land where I was before, which is that the determination of where the meeting happens must reside with the public body and public official, and all of the other strictures, of course, should apply. In that case, then we would not have to revisit the question of public venue, because I do support what the SG said, that if we're going to keep this public venue thing here, then we're going to have to look at how we define that, particularly in the context of a bill that already has a definition for public place. May it please you.
What was your interpretation or understanding, Mr. Edwards, of of the definition of public venue. You guys,
My understanding of public venue is it's to some extent similar to what we speak of as a public place. I mean, a place that's accessible to the public, but it's not a strictly defined term. But it's a place that is accessible to the public and speaks to some of what Senator Golding Campbell was referring to in the guidelines, that we're speaking of activities that have some possibility of being open to the public. So that was what I would have considered in terms of public venue. It wouldn't be in camera, and there would be the possibility that other persons beside those who are just involved in the deliberations could.
Would that definition be captured if you replace public venue with public place? Not really.
I have no problem with public place. I have no problem
Because
with
you have a definition for public place, right?
We do have a definition of public
So I'm just
place.
wondering whether public venue as opposed to public place, is that substantially different? Because
It's just that, Chair, we wouldn't expect all the places contemplated under the definition of public place to necessarily be practicable for the purposes of...
No, I know, I understand
Yes.
that. So you wouldn't set
But it's
a
broad
meeting.
enough, it's broad enough.
You wouldn't set a meeting for the national arena, I understand that.
But
What
in some cases you may. But
But in that case, then, Mr. Edwards, if you're going to use the definition of public place, that room that you turn into a conference room upstairs on the 4th floor of the hotel, would that qualify as a public place? Is that a place that can be used collectively by the public
They're paying
in that
for
sense?
it.
So,
Yes.
I mean, I think we have to think of that.
it depends on the circumstances of the case. You can make it accessible and open to the public, wherever it is.
Available to be used. Okay.
Yes, Kadian, and hopefully we can wrap this segment up.
Thank you, Chairman. You had asked earlier if there were examples.
Right.
We had looked quickly at the Ghana's legislation, and they speak to in their Tobacco Control Act where there is any interaction between the government and the tobacco industry. The government shall ensure full accountability and transparency of the interaction, including, where possible, public participation in or public record of such interaction. So perhaps in looking at how we can address the concerns raised, we could look to see how we, if possible...
That doesn't speak to venue, though. It only
But if we
speaks
could
to...
extend to
And I think
where
we've al-
possible public place or public venue.
It doesn't say that.
It doesn't, but we could. So it
Well, which is the contentious issue, because the bill already speaks to all of those items that I think you have mentioned. But the issue now
Sorry,
is
Chair?
where.
Sorry, Chair, the big takeaway from what was just read, it reinforces what was said in the guidelines. It said where possible, which is not even in this bill. It said where possible. Because you still need to have, with respect, some amount of flexibility. You really do. I know of this from where I sit, because from time to time we are asked to now interpret laws. We have to go to court on them. And you would be surprised about the nuances that come up.
I appreciate
and
that.
I would really suggest that you consider the flexibility, which is even in the guidelines, which I will remind you, guidelines are just guidelines, they're not requirements.
So what I'm suggesting then, as a happy compromise, if there's such a thing on this issue, is that we go back to where we had indicated that it is recommended that this happens where possible.
Or as practicable.
As far as which is encouragement too, but wouldn't require as a sort of mandatory requirement. With all the other provisions, of course, of transparency, the record keeping and all the. Yeah.
So, Mr. Edwards, where do you insert as far as practicable? After shall ensure?
After the word ensure in subsection 5.
So are you going to take out then only?
We could take out only.
Yeah. So you
Shall
have to take
ensure
out
as far.
only.
Yes. So it would be shall ensure as far as practicable that the interaction takes place in a public venue determined by the public body.
So the flexibility of it and the control is what is determined by the public body.
Yes.
Yes, yes. But the flexibility though, you know, which I think this SU was saying is that is just allowing for where necessary. But the default position should be that it takes place in a public venue. So every effort should be made
All right.
to
So,
have it occur
Mr.
in a
Edwards,
public
in the
venue.
interest of just sort of managing this to a close, putting that as far as practical and let us move on, because I think that that could address the concerns while allowing for some flexibility. Okay? With everything else, the transparency, the recording, and that sort of thing. All right. It's 4:28. And so we are close to the 4:30 timeline. Do you want to do one other, or is there, or time doesn't permit?
No, Chair.
All right, go to number 6 then. No?
We had touched on it briefly. Subsection 6, interactions with the tobacco industry shall not take place within offices or other facilities of the tobacco industry, except where necessary in the course of law enforcement activities.
Are there any objections to that? Senator Longmore, you have an objection?
With respect, sorry, I was engaged with.
I know you were,
sensible-
but do you have any objection to what was just read?
As far as practicable?
You're going back to we're at number 6 now.
Sorry, I was in a discussion around as far as practical because I'm trying to understand what the definition of that is. And just state for the record that I absolutely don't agree with that decision, but that's noted. Sorry, can you please repeat? Sorry.
So subsection 6 reads, interactions with the tobacco industry shall not take place within offices or other facilities of the tobacco industry, except where necessary in the course of law enforcement activities.
That's pretty straightforward, is it?
Law enforcement activities?
Law enforcement.
What is the law enforcement activity?
It could be
Audits,
police investigation.
inspection, audits,
It could be
all of that.
seizing,
That can't be the only reason law enforcement is permitted to interact with
No,
the
I
tobacco
said
industry.
no. I'm giving a range of options. It could also be that there has been some discovery that there's a need to seize or obtain, or that there's evidence that there's been a breach
Mr.
of
Edwards,
the law.
the point I'm making to you is that law enforcement operates and engages with the public outside of activities that involve arrest or evidence. The same community policing we're talking about happens at the level of commerce and commercial enterprise. So if my area, what do you call it now? What do you call it? I can't remember. If my divisional commander wants a meeting with the head of Carreras because that's in his division to discuss, is that considered law enforcement activities?
Law enforcement suggests that there is some issue in relation to possible breach of law or investigation of
And I'm suggesting to you, sir, that we not restrict how the police engage at the premises of the tobacco industry, because I don't think it would be inappropriate for the police to attend at the tobacco industry facilities to have discussions about crime in the neighborhood, for argument's sake. Why would we wish to insert ourselves between the police and how they engage?
But law enforcement isn't only carried out by the police with respect Because we're talking about enforcement of the law. Suppose we're speaking about the inspectors enforcing the provisions of this act. It's not necessarily police, it could be customs, it could be other persons.
Right, so that's the question I asked you, Mr. Edwards. I was asking you to explain to me what you mean by law enforcement activities.
And I was giving some examples.
And you're right, and those examples all surround enforcement of particular provisions, whether of this law or any other. And I'm suggesting to you that there's some engagement between law enforcement, and I'm thinking in particular of the police, that are not about enforcing any particular provision, but is about the work of the police in a particular neighborhood. Yes. And about the engagements that the JCF has.
Okay. Yes, so there could
with
be
business. Is that law enforcement
It could be
activities?
Also, it may not have anything to do with tobacco activities. That's true.
Sorry. Mr. Edwards, is there a way to phrase the work of the relevant authority agencies that captures a specific approach to engagement? I mean, law enforcement, I think broadly defined, could include customs, it could include law enforcement around the premises, as well as any breach that the tobacco company themselves may have taken. Maybe that's too broad a definition, I don't know. I mean, that's my understanding of what Senator Campbell is saying, that maybe if it is interpreted literally, then it's a restriction on those agencies. Is it intended to be interpreted literally? And if is there another way to phrase it to give it a sort of wider scope of possible engagement?
Well, the question then, Chair, is what would the committee wish to have as the basis for interaction taking place at the tobacco industry facility?
Chair, can I? This is only relevant in relation to the public official that is that public official in the ministry responsible for health and under which this tobacco legislation sits, you know.
No, it's much broader. Because the term interaction is speaking to public officials, not just the Ministry of Health officers.
Yeah, it's a broader.
Much broader. It's much broader. It's much broader.
So it's basically restricting meetings at the premises of this establishment unless there is some sort of regulatory function that
which is
to take
precisely
place.
the objection I'm having, because interactions is defined as it is defined, which is a business meeting. Then it means that you are saying that the JCF cannot go to the tobacco industry office and sit down and have a business meeting.
Why would they do that?
The JCF do these things all the time. As far as I know, and I don't mean in relation to the tobacco industry, but you will have in a community officers who come around to meet the newcomers in the community, to have discussions about things happening in the community. I've seen it happen. It used to happen when I was a business owner back in the day. They come, they check on you, how are things, and they talk to you about various initiatives that they're undertaking in the community. That's a business meeting. But I just don't feel comfortable inserting myself between law enforcement and any industry, not just the tobacco industry.
Chair, if I may.
Yes.
I'm always coming from the perspective of less is more, and do we really need something? This law can't restrict or regulate how law enforcement carries out their job. This law cannot tell the customs officers they can or cannot interact in a manner consistent with their law. Neither can this law tell the police or MOCA or anybody else. Do we need to put in this exception? I thought when I saw it first that it would assist if there was, say, some function of an inspection. So if you had a regulatory function and you were going to do like inspection of premises and so on, that you would perhaps really, this provision could be useful. But I don't think we even have that scheme in this bill. I can't recall us having that kind of scheme in this bill. When we're talking about law enforcement here, if we are talking about our normally understood law enforcement agencies, this can neither prevent them from interacting in a manner in which they are going to interact, because they also operate whether under common law or other statutes. So if this is to deal with police, MOCA, JDF, customs, and so on, we don't need it. We don't need these words. If we would only need these words if I think we had some sort of inspectorate, someone who is going in to do inspections.
Which is why
and so
I was
on.
saying that if we could rephrase it to speak to, because what is the injury we're trying to correct here, to address? To my mind, my layman's non-legal mind, is that it is trying to discourage or indeed prevent the tobacco companies from accommodating conversations at their premises involving the promotion or support of their brand, and basically saying, you know, we should not visit upon and participate on their premises, on their turf, sort of thing, which I can understand why, but clearly we can't restrict the regulators from engaging in the course of their duties, and certainly, as you say, law enforcement from interfacing at any point in time. So maybe law enforcement is the wrong terminology. Maybe we should replace that by saying on no meetings at these locations unless these are related to the regulatory functions of the relevant agencies or something like that, to capture those that would need that flexibility, and by law have that flexibility to engage. I don't know if you understand what I'm saying.
Before you go, subject, because you would have advised us in relation to what the Kenyan legislation said, and 6 is what is depicted in 6 is clearly different from what is depicted in here now. Can you advise us as to the intent as to what the Kenyan legislation says, and recommend if that is a more suitable approach?
So the Kenyan legislation was narrower in its focus. I can't speak to real intent because I can only tell you what I see on the page. And it spoke about it wouldn't apply where you are enforcing compliance with law or ensuring compliance with law. That is much more restrictive. It is much more direct in its focus. But again, I am not sure that we really need that kind of provision. I was just thinking about the JCF and how they do community policing. That is not necessarily enforcing a law. It's not necessarily, it's reaching out, it's having dialogue, it's communicating with persons in a way that you don't expect normally from police. And I think the issue that even Senator Golding Campbell was getting at is we want to be careful about what we prescribe.
What of my suggestion around regulatory agencies? Rephrasing it to
So I take that point. I just don't know if Mr. Edwards would have the words to, because I'm not sure which regulatory agencies.
Let me tell you why I worry about not having a clause like this. It leaves it open to people organizing tours and, you know, social events and, you know, and so on. And that is a form of influence. Potentially, it is a form of influence. Anybody. It could be distributors. It could be anybody. So I think you have to Sorry? Well...
Sorry. Chair, if I may, could we then limit it to dealing with the authorized officers who are going to conduct inspections? Because we have that Part 9 of the bill, the enforcement provision of the actual bill. 27 talks about the function of the authorized officers, where they conduct inspections and so on. Perhaps we would want to then focus that provision to these persons to say they are allowed to still go ahead and do their job, and they wouldn't now be restricted by all of this. We need to have 2 persons, we need to notify, right?
Right, now I get you. So you'd address the issue of the first part of the bill, the clause, and then at the same time not do any injury to the law enforcement component or concerns that were raised by Senator Golding. So, Mr. Edwards, can you rephrase that? Huh?
Can I hear again where we want to go, Chair?
So instead of speaking broadly of law enforcement activities, we would perhaps just focus the attention on the authorized officers who, under clauses 27 and so on, carry out and perform inspections. So they have to go on the property to conduct quote-unquote law enforcement activities, such as, well, right now the bill talks about inspections, going in to examine, take copies, interview, and so on. So perhaps we could link it to these activities of the authorized officers, so it is clear that even though we're saying, because these authorized officers are public officials, so even though we have restrictions on how public officials are to interact, we would be saying that these authorized officers, although they are public officials, are not restricted by those provisions.
Okay, so then we cross-refer this to specifically
Right. So
those.
instead of just saying generally law enforcement activities, because law enforcement activities could include these things, but it could include so much more.
Yeah, no, I take the point.
But I thought it was intended to cover more than just those
I'm
activities.
sorry, Chair, it doesn't change it though.
Yeah.
With respect, SG, when we look at the definition of public official, which is what is captured in the definition of interaction, it includes members of the security forces. It includes persons employed to a public body or performing a public function. So if
Yes,
that...
and we have comments on those definitions as well, because you will know
I recognize that.
So I was going to address
I recognize.
that
So
at another
unless we're going to remove, we're agreeing to remove security forces from that definition, then the remedy that you're suggesting in terms of the authorized officer would still capture the security forces, which is what I think we should...
And that was going to be our suggestion, because I've asked the question before, and we still ask it again.
Why they're in
Why
there.
are the security forces included in this?
Agreed.
Right.
All right, so what's Mr. Edwards? Would you need some time to figure that out?
Yes, but I heard a question about security forces. Are we talking about why security forces should be included as public officials in this context? Chair?
Is that what you're saying, SG?
Yes, so the concerns we had before still remain with those definitions and the reason they were included. And part of it is, I recall, some of it coming from the Integrity Commission Act, except this bill does not take the definitions wholesale. What it does, it picks parts of it and leaves parts. And we still are querying why would security forces be included as public officials. We still don't know why we have included some and removed some. We raised judicial officers, and I noticed, I think, those have been removed. But we still don't know why we have... You see, what is the intent and rationale of this bill? And when you look at what the Integrity Commission bill is capturing, that's on a wider scale. That's corruption, where we're implementing certain international obligations, and we had to take those specific types of definitions. There is no such obligation here, and so we still query the kind of definitions we are including in terms of like things like public official to include security forces.
Edwards?
Yes, Chair. I hear the SG and, do countenance her opinion very seriously, but we, from our perspective, would have to be convinced why the security forces should not be treated as public officials for the purposes of legislation like this, and the consequences of interaction between officials and industry in the reality of the Jamaican society. But I say no more.
So you're saying that the security forces theoretically, or members of, could become purveyors of the tobacco interests? Theoretically. So they should be captured in the net, even though they have a primary burden to pursue and enforce the law. What she's saying is that the SG, is that the issues around corruption related to that is captured elsewhere in other pieces of legislation. Is that what I'm understanding you to say?
Yes, so I'm still trying to understand who are we trying to cover under this legislation. Are you saying that a police officer is going to act in such a manner that you have to restrict their interaction with the tobacco industry? But you were able to, but that's what you're doing here. When you define,
but in effect, we're saying that about every public officer.
No, but we have now removed judicial officers.
Except
right?
judicial.
Exactly. So then why did we remove judicial and not police? I'm just saying in most other legislation, we would not have included the security. Let me go further. In security, are we including the JDF? The JDF are not even public officers within the meaning of the Constitution. Why are we including them here? What threat does the JDF pose for this legislation? Because I think you always have to go back to the intent. What is your original intent? How does the military play any major role here? I would have thought that at the outset, what you were looking at were public officials, as in civil servants, persons in ministries. You have gone even further now to talk about public bodies. And public bodies, remember, Jamaica has gone a lot further than some other places to have all of these statutory bodies. We have executive agencies. We have gone very far when you talk about what I consider the wider public service. The public service that's not contemplated in the Constitution. And I'm saying, why are we trying to extend the ambit of this law all the way across? I am still very unclear about it. And I have this concern because of the restrictions in this law. The restrictions that we have in this law that we have nowhere else in any Jamaican law. And you have to be clear about why you're going to impose it on such a wide cross-section of persons. And I'm still very unclear about that.
Well, I can tell you why this law is different from any other law. Certainly from a public health perspective, the tobacco legislation globally, by all accounts, have been unique, if that is a word, because it speaks to a practice that is almost a zero-sum game. I mean, you smoke, there are consequences, and very devastating consequences, not just on the person, the individual, but on the collective. Secondhand smoking, on the community, on the taxpayer, on the country. And so that industry has always been approached in terms of legislation with levels of extremity, if you want to classify it as such, in terms of what is imposed on those who exercise their right to smoke, as well as those who may be impacted by the consequences of smoking. So I accept that there are going to be clauses that may be extreme in that regard. The question, though, is whether or not it runs into conflict. I'm more concerned about the conflict of what we are proposing with existing laws or in the public official carrying out their duty. That is what I'm more concerned about, which is why I say, Mr. Edwards, one has to manage that balance.
And Chair, one way in which we sought to manage, and we were guided by the AG's chambers through the Solicitor General, was to keep using the Kenyan model, was to have some separation between the obligations on the public official and on the public body, and furthermore, distinguishing the kind of sanctions that you impose. So, for instance, these provisions dealing with interaction do not have the level of sanction that you have in relation to the provisions dealing with conflict of interest, dealing with accepting gifts, dealing with dealing with disclosure of interest and so on. These provisions dealing with interaction do not attract the same type of penal sanction as those other provisions have. And those other provisions apply largely to persons who are involved in policy making, in public health. These provisions dealing with interaction are the broad-based provisions that seek to separate the public official in the widest context from the tobacco industry. Where you drill down to more serious punishment is where you're dealing with persons who actually have public health policy roles. So
Right.
that is one way in which we have sought to separate and distinguish the categories.
Mr. Chair, I know we're close to 5 o'clock, and you're going to say that you probably had a long day, but if I might, whenever this Solicitor General brings up the caution in terms of what exists in other legislation or the Constitution, which we are always to be guided by, my ears perk up and I pay very close attention. If it is that this provision is seeking to go beyond where we should be contemplating, then we probably need to be guided. I mean, what is the real reason for including this section if we don't have, if there are so many questions about it? And I'm wondering if we shouldn't be considering not including this one here at this time.
Except that I'm very sensitive to the SG's, depth of knowledge around the formation of legislation and so on. I think that's very important to the balancing of the conversation here. But I think we have to also be careful that we're not comparing apples with oranges in terms of the nature of the legislation. So I am more sensitive to an argument, SG, that says the Framework Convention, of which we're a signatory, around tobacco control, we are going way left of what that convention is saying, or in jurisdictions around the world, when you compare similar tobacco legislation, we are taking it to another level, rather than to say the laws around tobacco control that we are promulgating is very different from how we promulgate laws around the control of other activities within the society. That is where I have a concern, because I don't want us to treat the tobacco industry, which we have not, or globally have not, whether locally or globally, on a sort of equal footing in terms of the nature of the legislation. So, which is why I'm happy that we have a, I'm coming to you, which is why I'm happy we have a PAHO as a reference on things like the Framework Convention in this discussion, because while I don't want to be unfair to any stakeholder who is legitimate in the society and has a legitimate claim to practice, I want to also be guided by what those international norms are in terms of the nature, the context of this particular legislation. So maybe one of the things we need to do is to ask PAHO, WHO, how does this particular clause deviate or is similar to the Framework Convention or similar types of legislation. And if we have to come back to it, I'm prepared to come back to it at the next session. Hold on, the Solicitor General wanted to come in, and then we're going to wrap up shortly, by the way. We may have to wrap up with this clause as a work in progress, but go ahead.
It's not so much the clause, it's the definitions that I've raised an issue with. And the issue isn't so much that we're doing something here that we haven't done anywhere else, because you can always justify it. When I asked, where did these definitions come from? I was told the Integrity Commission Act. And my point is, we can't just pull from one act and stick it in another act, because you have to have a rationale for why you're going to put something somewhere. There is a rationale for why we have this very wide definition of public official, public body in the Integrity Commission Act. I still am not satisfied that we need it in this law, and that is what I'm saying. Now, if I was told it was we're implementing an international obligation, that's one thing, but that's not what I was told. I was told we took those definitions from the Integrity Commission Act, and that's where I have my difficulty.
Right. So I guess the issue becomes the extent to which what you have been told reconciles with the international convention and the obligations that we have signed on to. So maybe there needs to be a reconciliation around that.
But that's what I thought our opinion, our comments spoke to. The Ministry of Health's memo recently spoke to implementing the obligations under the Framework Convention.
This is the point. So how different is that from
For police and for judges, that's what I'm talking about, not the clauses, you know. I'm talking about the fact that you have included in the definition people like categories of persons like police and judges. That's when I asked about those very specific entities. I'm not talking about the clause. I'm talking about the definitions of public official and public person and so on.
Okay,
that is where I have the difficulty.
All right. One issue, Chair and members, and I'm conscious of the time, would be if we're speaking about equality from a constitutional perspective, how would we justify keeping certain categories of officials out of these restrictions and limitations and others limited and restricted?
Sorry, but we have crafted something that we have crafted it. The military are not public officers under the Constitution, but you've put them here. So what I'm saying is this is not as if you would have to justify leaving someone out. You have to justify putting them in. Why have we crafted the definition this way for this law?
Chair, can I just make this intervention? Because I feel like I don't even know what's going on, to be honest with you, because these documents and the documents being referred to, I'm seeing for the first time today. These were these
been with us for about 2
No,
months.
I know those definitions, but I understand there is a Ministry of Health memo that explains these things, which I think is this document that was put on the desk today. I only got this.
About a week or two ago.
One document was circulated this morning, but the rest were already in the system for a while. All right.
So what I was saying, Chair, can we maybe put this over to the next time so that we have sufficient time to look at it?
That's where I'm going. I think it's 5 o'clock now, and we've been at this for 3 hours, and after a while, diminishing return sets in. I would say, though, that I tell you what, after this is done, I'm going to ask kindly for a quiet session with the SG and Mr. Edwards' office. Can I just have 5 minutes with you after the meeting, please? I know it's late and I know you have obligations. Just 5 minutes, please. All right, so we're going to close here and pick up from where we left off. Next meeting, we have some dates here. Any other business in keeping with the agenda? No other business? Okay. Next meeting, we have October 27th, 2 p.m. proposed, November 1, 10 a.m. That's a Tuesday, and November 3rd, 10 to 2 p.m. That's a Thursday. I don't mind logging these dates, or at least 2 of these dates, to try and see how far we can get. Is October 27th at 2 p.m. on a Thursday okay?
No, Chair, not good for me.
Not for you? Not for you?
It's going to be difficult for me.
Oh. It's good for you, both? For you? All right. It's your birthday?
Not
Oh,
good,
your
not
mother's
good for
birthday.
me.
Wow,
Not-
okay.
Chair, it's not
Yes.
good for me. Not good for me.
Not good for you. All right, Mr. Edwards, you're essential. What about November 1, 10 a.m.?
Can work
November
with
1?
that.
That's a Tuesday. Are you okay with that, member guy?
I am, Chair.
I may have to join virtually for that week,
That's
sir.
fine. We'll allow. And yeah. All right, I think we should settle on November 1. What about November 3rd? That's a Thursday. Oh, we can do
No,
1 and
sir.
3 if
No,
necessary. Suspect we'll need the time. November 3rd?
No, Chair, not for me.
Anybody else? 10 a.m. Yeah? So let's log these 2 dates, November 1 and 3rd, and try and see how far we can get through with this. Same week, we'll carry over the minutes. Let's try and do that. We really are. The 3rd is 10. Both of them are 10, actually. What? No, what you have here? You have November 10 or 2 p.m. Okay, would you prefer 2 p.m.? 2? All right, let's do that. Let's do November 3rd at 2, November 1 at 10. All right. So, date for the next
I
meeting.
can join them by Zoom for 2.
Excellent. So that will be acceptable. All right. So can we then thank you all for being here? And at 5:03, the meeting adjourned. Thank you.